872 words, within the 855-945 target range. Here's the finished script. There is a presidential tool called the signing statement. It appears in no law you've read, and it has been used to quietly rewrite the meaning of more than 1,200 provisions of federal law without a single vote in Congress. Here's what it actually is. When a bill lands on the president's desk, he has three options: sign it, veto it, or let it become law without his signature. Everyone learns that in school. What they don't teach you is the fourth option, the one hiding inside the first. The president can sign the bill into law and on the same piece of paper attach a separate statement declaring how he intends to interpret it. Sometimes that statement quietly announces he won't enforce a section at all. The bill passes. The statement isn't a bill. It never gets a vote, and courts for decades have treated it as evidence of what the law actually means. By law, only the version of the bill Congress voted on is supposed to matter. But in 1986, a Justice Department lawyer named Samuel Alito, years before he sat on the Supreme Court, wrote an internal memo with one goal: get signing statements published alongside legislative history in the same official record judges use to interpret ambiguous statutes. The plan worked. Signing statements started appearing in the U.S. Code, congressional and administrative news, sitting next to committee reports and floor debates, the very materials courts consult to decide what a law means. From that point on, a president's private objection, written after Congress had already finished voting, could shape how a judge reads the statute years later. No amendment, no hearing, no repeal vote, just a paragraph attached quietly, absorbed into the law's memory. Once that door opened, the tool stopped being rare. Every modern president has used it, but the scale changed fast. George W. Bush issued signing statements challenging over 1,100 provisions across his 2 terms, more than every previous president combined. In December 2005, Congress passed the Detainee Treatment Act, banning cruel, inhuman, and degrading treatment of prisoners in U.S. custody. Bush signed it. Then he attached a statement asserting he would interpret the ban in a manner consistent with the constitutional authority of the president. As commander-in-chief, language legal scholars read as reserving the right to bypass the very ban he'd just signed. The law said one thing, the paragraph beside it said another. Both now sit in the same federal record. And here's the part that should actually worry you: it's completely legal. No statute forbids it. No court has ever struck down a signing statement itself, because a signing statement isn't an order, it's a declaration of intent. It doesn't do anything on its own. It just sits there waiting until an agency needs cover to not enforce a provision, or a judge needs a citation to resolve an ambiguous phrase. It's a lever with no fingerprints. Federal employees inside those agencies are trained to know the difference between the statute and the statement sitting beside it, which sections they can quietly decline to act on, and which ones still carry teeth. That knowledge almost never reaches the public it governs. Remember, no one voted for this. Not the mechanism, not its use in any specific case. Congress voted on a bill. The president voted alone on what that bill would actually mean once it left his desk. You cannot repeal a signing statement because it was never a rule to begin with. You can't undo something that was never officially made. Congress could pass a law forbidding future signing statements, but that law would land on a president's desk too. And it could be signed with a signing statement explaining why the president doesn't consider it binding on his own office. The mechanism protects itself by being the exact thing it would need to override. It isn't written into the Constitution, isn't defined in the U.S. Code, and isn't reviewable by any court unless a plaintiff can prove a concrete injury from how it was later used, which, by design, is almost never traceable back to the paragraph itself. Every attempt to close the loophole has to pass through the loophole first. This is the part that should reframe everything else you think you know about how laws work. If the meaning of a statute can be quietly amended by the person enforcing it, on the day he signs it, then every law you've ever read is really 2 documents. The one Congress debated in public, and the one the executive branch privately reserved the right to follow. You will never know, reading the text of any given law, whether a signing statement sits behind it waiting. Most citizens never find out these exist. Most journalists don't check. The agencies enforcing the law already know which sections carry an asterisk, and they have known for decades that the public does not. So the next time you read a law and assume it means what it says, ask yourself who else read the same bill on the same day and quietly decided it didn't.